Here in Chicago, one of the big pieces of news last year was a controversy over hazing at Northwestern University. There were incidences of alleged hazing at the Northwestern Wildcats football team. There was an investigation that ensued. Coach Pat Fitzgerald was terminated and has since sued for breach of contract for the termination. One of the interesting factors of this whole story was the fact that Northwestern hired a lawyer to conduct the investigation. The terminated coach hired a lawyer to seek a remedy for an alleged breach of contract or even a wrongful termination. But what about the players? Were the players represented? Who was speaking for them? For the most part, the answer was nobody. They did not have representation. The university didn't necessarily afford them the right to retain an attorney that would speak for the players. And they were not afforded an attorney to be involved in any school investigation. In this day and age, where all of a sudden college players are now allowed to earn money for their image and likeness, an important question arises, which is, are they employees of the university or are they employees of the NCAA? A lot of law has changed regarding their status as student athletes. Given the amount of money that they bring into schools, the old requirement that they could not earn a living, for many of these student athletes, this was a very difficult predicament to be in. A lot of athletes didn't have money to live and go to school, but they weren't allowed to make any money, and that has changed. They now can. As a result of a performance that they conduct, namely engaging in a sporting activity, they can be compensated for it. That sounds an awful lot like an employee. So as an employee in a situation as the Northwestern one, would those employees have been eligible to have a particular attorney represent them? Well, perhaps not. As an at-will employee, you don't necessarily have any rights to include a private attorney in an in-house investigation. I tell people all the time that a company's investigation doesn't follow any certain set of legal requirements or protocols. There's no due process in the employment setting. Just as if you were to be arrested and the arresting officer and the prosecutor had to follow certain rules, and if they didn't, your defense attorney could highlight those rules and possibly get you acquitted or have the case thrown out. That doesn't really exist in a company's own private investigation. So in that case, if a student athlete is simply an employee, they don't have a ton more rights than they would if they're just a student athlete. Taking this logic to the next step, if employees then what? Could they form a union? It seems as though perhaps they can, but how would they form that union? Would it be the Northwestern Student Athletes Union? Would it be the College Football Union? Would it be the NCAA Student Athlete Union? How that's formed and the bargaining rights of any particular group is complicated and very detailed. There could be a particular union for college football. There could be a particular unit for men's and women's sports. Hypothetically, there could be one union for all of them. If they were to unionize, they would have far more rights. You know, one of the main features of unionizing is that one party, the union, and the other party, an employer, sit down and draft a collective bargaining agreement that affords the worker and affords the employer certain rights. In many cases, those rights include representation for some sort of investigation, be it an attorney who represents the union or a union steward that represents the union. They are given more rights, more protections in this situation. If the Northwestern football players had unionized or had a union, they would have had representation. That representation could have helped advise and counsel and protect them in case the university or any outside legal counsel wanted to speak with any of the athletes. If an athlete chose not to say anything, that wouldn't necessarily be held negatively against them. On the flip side, if the athlete chose to speak out and avail themselves of free speech rights or avail themselves of the right to assembly and speak on behalf of their union or speak on behalf of themselves, and if they were subsequently kicked off the team for speaking out, then they would have rights to grieve that. This is a fascinating question because in a time now where more and more athletes are making more and more money off of their name, image, and likeness, and gaining more rights to essentially earn some compensation for the performance they conduct and earn some compensation for the money that they bring in, then there's a question of what other compensation should they be afforded, or what other benefits should they be afforded. For example, sports do a number on your physical body. Should a college athlete have rights to certain healthcare benefits? Your average college athlete does not become a professional. Your average college athlete plays a sport in college and then goes to work like the rest of us. Only 1% of 1% become a professional. And so for the remaining 99% who play the same sport, maybe suffer the same injuries for the sake of the school, what about health benefits to them? Well, right now there are none, because there's no law that requires they be given one. They're not employees, and they're not in part of a collective bargaining agreement. However, if they were in a union, is it possible to negotiate some sort of health coverage for a certain number of years, say, after they leave the college or university where they've been a student athlete? These are important questions. I think there's arguments to be made that they should be afforded these things, given the fact that we now sort of think of them more as employees as we do students. It's a conversation that I think will be going on for years as we all figure out what rights they should have or what rights they seek to have.